I have received a lot of questions about the current antitrust lawsuit against the UFC. So instead of writing another long article on the subject, I thought it might be best to make something as accessible as possible, and so decided a short video explaining why the UFC is being sued, who is suing them, what the results could be, and where we are in the process was in order. So why is the UFC being sued? A group of former fighters, I'll discuss them in more detail shortly, has filed a lawsuit against the UFC, accusing the company of violating Section 2 of the Sherman Act, which makes it unlawful for any person to monopolize or attempt to monopolize or conspire to monopolize any part of the trade or commerce. So while it is not illegal to have a monopoly, it is illegal to intentionally attain one or abuse your position as a monopoly. This is what the fighters accuse the UFC of having done. They allege that the UFC violated antitrust laws by engaging in a scheme to maintain and enhance their A. monopoly power in the market for promotion of live elite professional mixed martial arts bouts, and B. monopsony power in the market for live elite professional MMA fighter services. The result of the scheme, according to the plaintiffs, was fighters' pay being suppressed well below what a competitive market would have paid. Before going on, let me explain monopsony power. That is the opposite of monopoly power. If you look up monopoly in the dictionary, it will describe it as being the sole seller of a product. So monopsony is the sole buyer. This is, of course, the dictionary definition. But when monopolies or monopsonies are used when discussing antitrust, it refers to market power, not the dictionary definition. So a firm has monopoly or monopsony power not by being the sole buyer or seller, but by having such a dominant position in a market as to control the setting of the price. Typically, firms have been required to have more than 50% share of a market before the courts will find that they have monopoly power. In this case, the UFC is thought to have as much as a 90% share of the market. So the plaintiffs in this case are accusing the UFC of having gained such a share of the market of MMA that they have monopoly power over the sport. And because they have monopoly power over the sport, they have monopsony power over elite MMA fighter pay. So how did the UFC do this? According to the plaintiffs, the UFC scheme involved 1. Locking fighters into long-term exclusive contracts. This included the use of tolling provisions. So let's say a fighter finishes his 5-fight, 2-year contract. Is he ready for free agency? Well, no, because if the UFC wants, they can extend the contract 6 months for every time the fighter was out for injuries or personal reasons or whatever. And if the fighter is a champion at the end of his contract, they can also extend it with the champions clause. So that 2-year contract could end up lasting much, much longer. 2. Using its market dominance to coerce fighters to re-sign contracts. Such coercive tactics, including moving fighters to unfavorable placement on the card, or giving the fighter an unfavorable matchup, or depriving them of title opportunities if they didn't sign the contract offered by the UFC. 3. Acquiring and then closing down other MMA promoters that threaten the UFC's dominance. The most famous examples of this is Pride in 2007 and Strikeforce in 2011. With the purchase of these promotions, not only was another option denied fighters, but a large number of elite fighters were now under exclusive Zuffa contracts and removed from the pool of available fighters for non-Zuffa fighters to compete against. The plaintiffs allege that because of the scheme, the UFC can pay less than 20% of their revenue to fighters, whereas with other sports like the NBA, NFL, NHL, and Major League Baseball, it is closer to 50%. And for the other combat sport of boxing, it is even higher, with boxers regularly getting paid 60 or even 70% of the revenue collected by a promoter. According to the plaintiffs, UFC fighters should have been paid like these other athletes, and they are owed hundreds of millions from the UFC. Plaintiffs' experts have estimated that during the class period, which goes from December 2010 until the end of June 2017, the UFC should have paid their fighters anywhere from $811 million to $1.6 billion more. While the plaintiffs' allegations are a little complex, the UFC's defense is pretty simple. There was no scheme. The UFC's contracts are no different from those used by other MMA promotions, and the only reason they have such a large share of the market is because they are just that much better at promoting fights. That is because of their actions, the so-called secret sauce that makes the UFC brand more appealing to fans than the fighters themselves. And while, as a percentage of the revenue, fighter pay may be low, fighter wage levels continue to rise, and the UFC says this is the proper metric by which to measure. So who are the plaintiffs in this lawsuit? The first three fighters to file a complaint against the UFC were Kung Lee, Nate Quarry, and John Fitch back on December 16, 2014. Over the next few months, 4 more lawsuits were filed, with 8 other fighters attached. Eventually, all those suits were condensed into one lawsuit, with the original 3 joined by Javier Vasquez, Brandon Vera, and Kyle Kingsbury as the named plaintiffs. Originally, the plaintiffs were suing on behalf of 2 different classes. The bout class, those fighters that fought in the UFC, and the identity class, those fighters whose image rights had been used by the UFC. The judge has indicated that he is certifying the bout class, but is not certifying the identity class, which means Nate Quarry will no longer be one of the class representatives, as the bout class continues as a class action lawsuit. A class action lawsuit is when a small group of individuals can sue on behalf of a larger group. The class the plaintiffs are trying to represent are any fighter that fought in a bout that was either held or broadcast in the United States at any time between December 16, 2010 and June 30, 2017. The size of the class, therefore, would be over 1,200 fighters. The judge has indicated several times that the class will be certified, so the 5 named plaintiffs will be representing all these fighters. So what do the other 1,200 plus fighters in the class have to do? Nothing. They are automatically in it unless they specifically opt out. They can just wait around and see if the plaintiffs win. If they do, they'll also receive a portion of whatever is awarded. Apparently, some fighters have been contacted by attorneys asking to represent them for the case. Fighters should know that they don't need any representation if they don't want it. As I mentioned, they're automatically enrolled in the suit. And if the fighters win, they will be contacted or sent money that's been awarded. If fighters are interested in following the case, the plaintiffs have set up a website that allows them to subscribe for updates. So what are the possible outcomes? Well, obviously, the UFC could win summary judgment or a trial if it eventually came to that, in which case the fighters would get nothing. But if it goes all the way to trial and a jury decides in the fighters' favor, then the fighters could be awarded an enormous sum. The plaintiffs' economic experts have put forth estimates that the fighters were underpaid anywhere from $811 million to $1.6 billion. And on top of that, this is an antitrust case. And in antitrust cases, damages are trebled, which means tripled. So that $811 million to $1.6 billion would be multiplied by 3, or $2.4 billion to $4.8 billion in damages. In addition, the plaintiffs are asking for injunctive relief, requesting that the court come up with a solution to dismantle the UFC scheme. So on top of the money, it's possible the court could decide on something like limiting the UFC's contracts to no more than 1 or 2 years max, without any extensions at all, even if a fighter was injured, won a title, or just sat out refusing to fight. It's because of how potentially crippling such a ruling would be to Endeavor's business that I'm pretty confident that if it gets close to a trial, we will see the UFC settling. For how much, it's impossible to say, but I've read that the average antitrust lawsuit settlement is for around 20% of the potential damages. So it'd definitely be in the hundreds of millions. In addition, the class representatives seem fairly adamant about having some kind of remedy, so you'd have to expect some sort of contractual limits, but I can only guess as to what that would be. We still have a ways to go before that's even possible. As mentioned earlier, the case was originally filed in San Jose, California, back on December 16, 2014. Since then, the case has been moved to Las Vegas. The plaintiff survived a motion to dismiss by the defendants. We've gone through deposition and discovery, which is where we got documents that showed us how much the fighters had really been making, had a week of hearings, and now are waiting for the judge to file the written opinion for class certification. That should be coming soon, along with perhaps more unsealed documents. The UFC has already said that they'll appeal the class certification to the Ninth Circuit. If the petition is granted, then several more years could be added to the case, and the class certification could be overturned. If the court does not grant the petition for appeal, the case would move forward to the motion for summary judgment, where the UFC is asking for the judge to decide in their favor. That seems unlikely. So if we get to summary judgment, after that would be a trial. If everything goes the plaintiff's way, that could be as soon as next year. But that, of course, depends on how the appeal goes. And if we get to trial, I fully expect there to be a settlement because of what I said about the risk to Endeavor earlier. Hopefully this has been informative. If you have any questions, feel free to leave them below in the comments, and I'll try to answer them to the best of my ability. Otherwise, this is John S. Nash saying thank you. Hope you enjoyed this.
It's not in the face! Thank you.